One of the executive orders Donald Trump signed on his first day in office ordered federal departments and agencies to not issue any citizenship documents to anyone born in the United States to a mother who is either illegally or temporarily in the United States unless the father was a citizen. It should surprise no one that this order stirred up controversy. Of the several lawsuits that have been filed, I've found one thing in common: an inability to read the law. So we'll discuss this next on the Constitution Study.
Lovely neighbors and have a few good friends. Every day we're everyday Americans. Oh, every day we're everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study, where we read and study the Constitution. Teach your action generation be free. I'm glad you could join me today. Birthright citizenship obviously has been in the news lately. It's been talked about by a lot of people, but very few seem to go to the actual law, the Constitution, or even the purpose for the language in the 14th Amendment. So that's what we're going to do today. I've got more about this. I've got the article I've written and other content on the website, but I'll talk about that at the end of the episode. For now, let's get into this question of the birthright citizenship versus the Constitution. Let's start by looking at the executive order that started these particular legal issues. Section 1 is titled Purpose, and it reads, "The privilege of United States citizenship is a priceless and profound gift. The 14th Amendment states all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside." That provision rightly repudiated the Supreme Court of the United States' shameful decision in Dred Scott v. Sanford, which misinterpreted the Constitution as permanently excluding people of African descent from eligibility for United States citizenship solely based on their race. Now, Donald Trump sees U.S. citizenship as a priceless and profound gift. He even quotes the 14th Amendment and its purpose. Now, as the EO points out, the 14th Amendment states, "All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside." And what was the purpose of this language? Well, as the EO states, it was to repudiate the Supreme Court's decision in Dred Scott v. Sanford. Reading about that, I found, in a decision that was later nullified by the 13th and 14th Amendments, the Supreme Court held that former slaves did not have standing in federal courts because they lacked U.S. citizenship even after they were freed. In other words, the Supreme Court claimed that former slaves were not citizens and therefore did not have standing to sue in federal court. In one of the complaints, states of Washington, Arizona, Illinois, and Oregon versus Trump, we find the one mistake common to every other complaint I reviewed. Birthright citizenship is enshrined in the Constitution and federal statute. The citizenship stripping order is unlawful because its limited view of birthright citizenship is contrary to the 14th Amendment's text and history, century-old Supreme Court precedent, and long-standing executive branch interpretation, as well as the Immigration and Nationality Act. Section 1 of the 14th Amendment to the Constitution states, "All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and the state wherein they reside." This provision is known as the Citizenship Clause, and it contains no exception for children born to non-citizens or undocumented immigrants. While the complaint claims it contains no exception for children born to non-citizens or undocumented immigrants, that is exactly what the phrase "and subject to the jurisdiction thereof" means. So how can we tell what the meaning of subject to the jurisdiction thereof means? Well, in this case, it's pretty easy, since the person who proposed the language told us why. See, while the language of what would become the 14th Amendment was being debated in the Senate, one Senator, Jacob Merritt Howard of Michigan, proposed an amendment to the language. This amendment, which I have offered, is simply declaratory of what I regard as a law of the land already, that every person born within the limits of the United States and subject to their jurisdiction is by virtue of natural law and national law a citizen of the United States. This will not, of course, include persons born in the United States who are foreigners, aliens who belong to families of ambassadors or foreign ministers accredited to the government of the United States, but will include every other class of persons. See, Senator Howard specifically said he proposed this phrase, "subject to the jurisdiction thereof," that it would not include foreigners, aliens, or those belonging to families, ambassadors, or foreign ministers. Which means the claim that the Citizenship Clause contains no exception for children born to non-citizens or undocumented immigrants, probably known as illegal aliens, is obviously and objectively wrong. Now, also, since the Immigration and Nationality Act duplicates the language from the 14th Amendment, the complaint is just as wrong in that regard as well. Reading from Title 8, Section 1401 of the United States Code. The following shall be nationals and citizens of the United States at birth, a person born in the United States and subject to the jurisdiction thereof. So when the court claims that birthright citizenship is enshrined in the Constitution and federal statute, that's patently false. Many of the complaints point to a 1898 Supreme Court case, United States versus Wong, as proof that the 14th Amendment enshrines birthright citizenship. However, a quick look at the syllabus shows something very different. A child born in the United States to parents of Chinese descent who, at the time of his birth, are subjects of the Emperor of China, but have a permanent domicile residence in the United States and are there carrying on business and are not employed in any diplomatic or official capacity under the Emperor of China, becomes, at the time of his birth, a citizen of the United States by virtue of the first clause of the 14th Amendment of the Constitution. To start, while Wong Kim Ark's parents were of Chinese descent at the time of his birth, they were permanent residents of the United States, even though they were subjects of the Emperor of China. Hold on to that thought for a moment. The fact that issue was when Wong Kim Ark returned from a temporary trip to China, he was refused entry. But why was he refused entry? Reading from the syllabus, because the said Wong Kim Ark has been at all times by reason of his race, language, color, and dress a Chinese person and now is, and for some time last past has been, a laborer by occupation. It's interesting that the reason Wong Kim Ark was denied entry into the United States was because of his looks, not his place of birth. Now the court came to an interesting decision. The court ordered Wong Kim Ark to be discharged upon the ground that he was a citizen of the United States. But since Wong Kim Ark's parents were subjects of the Emperor of China at the time of his birth, he was not subject to the jurisdiction of the United States and therefore not eligible to be a natural-born citizen. What the court found was that because his parents had permanent resident status, they were subject to the jurisdiction of the United States, and that qualified him for citizenship. Was that following the law or the Constitution? Another case I saw referred to was Regan v. King. And in this case, plaintiffs claimed that 2,600 full-blooded Chinese born in the United States were eligible to vote. As the case notes, it was rather unique. This case is exceptional because the sole question it presents to this court is one which has been definitively decided by the United States Supreme Court. Is a person of the Japanese race born within the United States a citizen? Again, the question before the court was a question of race, not of jurisdiction. But since the Supreme Court had already decided the Wong Kim Ark case, this court extended citizenship not only to those who were children of permanent residents, but of anyone born in the United States. You remember when I asked you to hold on to a thought about Wong Kim Ark being a child of parents who were subjects of the Emperor of China? The Wong court tried to rewrite the Constitution to include permanent residents as under the jurisdiction thereof. Well, that may have been a logical position. It wasn't supported by the law. Then the Regan court extended that to include anyone born in the United States. In other words, the court's creeping decisions are used to try to make the Constitution say something it not only does not say, but in fact was the direct opposite of the legislative intent. Remember, according to the Supremacy Clause of the Constitution, a decision of the court is not the supreme law of the land. The Constitution is. So when the Constitution says, and subject to the jurisdiction thereof, that supersedes the decisions by these courts. Furthermore, when a judge places the decisions of a court above the supreme law of the land, they not only are violating their oath of office, but their duty to maintain good behavior. From Article 3 we read, the judges, both of the supreme and inferior courts, shall hold their offices during good behavior. So in this scenario, who is upholding their oath of office and who is violating it? Is it the attorneys and groups who filed these complaints? The judge who issued a temporary restraining order? Or the president who tells the executive branch to follow the language of the Constitution? Since the Constitution is the supreme law of the land, I think we know who's actually fulfilling his oath to make sure all of the laws of the United States are faithfully executed. This is not the first time I've had to talk about birthright citizenship, and I doubt it'll be the last. Because try as they might, they keep looking for these judges to say the Constitution says something it patently does not. To stretch and the wording of the Constitution to try and make it mean something. Does a permanent resident who's still subject to the Emperor of China, is that someone subject to the United States? Doesn't sound like it to me. Is somebody born here also a permanent resident? Not necessarily. So we have courts deviating from the language of the Constitution, defined by the meaning of the person who authored the words and subject to the jurisdiction thereof, yet people want to uphold that above the actual text and history of the Constitution of the United States. That's where the judicial branch makes such a mess in this country. And we are dealing, again, with birthright citizenship, not because of the Constitution, not because of President Trump, but because the courts keep placing their own preferences, their own decisions, their vain belief that they are the supreme law of the land above the actual supreme law of the land. Maybe if more of us learned what the Constitution said, including the fact that it is the supreme law of the land, we'd deal less with these crazy judges and these crazy attorneys. Now, if you want to find out more, if you want to find some of my references, as I said, there's an article posted on the website constitutionstudy.com. You can find that and more at that website. Sign up for a mailing list. Hey, maybe you want to ask a question. I love answering questions. You may also want to take this new course that I found called Miracle of America. It's a great little history of the United States from the colonies to the drafting of the Constitution. It's really very interesting. So interesting that I made a deal with the publisher so that you can get a free lesson so you can try it before you buy it. Just go to constitutionstudy.com/1776 study guide. That's the numerals, 1776 study guide. And you'll be taken to a custom landing page just for Constitution Study listeners. You can check out the course, see more about it, but more importantly, you can enroll for your free lesson on God's natural law. Give it a try. It's absolutely free. Something else you might want to try is Patriot Mobile, America's only Christian conservative wireless provider. Stop funding places and companies that are trying to destroy our rights, both directly and through the organizations they support. Support organizations that believe what we believe, like Patriot Mobile. They provide the same 4G and 5G coverage on the same networks and same towers that the major carriers use. But they support organizations that are protecting our constitutional right, including your freedom of speech, freedom of religion, freedom of the press, even your right to life. Go to patriotmobile.com/constitution, find a plan that works for you, maybe find a discount for NRA members or families with multiple lines, and then use the code Constitution at checkout to get free activation. Once again, that URL is patriotmobile.com/constitution to find a plan that works for you, and the code is Constitution to get free activation when you change your lines. I've been very happy with Patriot Mobile, and I'm pretty sure you will be too. Now, whether you do that or just head to the website and maybe go to the shop and buy a book or donate or just share these videos, these audio podcasts, whatever you do, I hope you come back here and maybe bring a few friends the next time we meet here for the Constitution Study.